has dismissed the appointment of the 50 chief administrative secretaries appointed by President William Ruto and termed them as unconstitutional. This is following a petition by the Law Society of Kenya and Katiba Institute challenging the appointment process.
For the avoidance of doubt, the notification by the first respondent dated the 16th of March 2023 appointing the second to 51st interested parties to the office of Chief Administrative Secretary is hereby quashed.
After the Law Society of Kenya filed a petition in court against the appointment of the Chief Administrative Secretaries in a landmark ruling, the High Court, led by Justice Kanyi Kimondo, has termed the appointment of the 50 CS as unconstitutional.
The current office of Chief Administrative Secretary, created by the first and fifth respondents and contained in the Kenya Gazette Special Issue number 12432, dated 12th of October 2022, and which announced the vacancies thereof, is unconstitutional. That the entire complement of 50 Chief Administrative Secretaries, which is to say all the second to the 51st interested parties, is unconstitutional.
The three-judge bench in their ruling also questioned how public participation was conducted, insisting that it did not follow the principles of the same.
On the flip side, the sequence and procedure that led to the establishment of the 27 additional posts did not adhere to the constitutional principle under Articles 10 and 232 of the Constitution and conditions set under Section 27 of the PSC Act. This process, in our opinion, did not satisfy the guiding principles set out by the Supreme Court in the BAT case. We say so because, as a guiding principle, public participation must be real and cover all forms of governance.
Despite the CSS taking their oath of office early this year, Justice Kanyi was skeptical as to why the number of their appointees was higher than that of the cabinet secretaries.
It is therefore our considered view that the creation of a similar office to the Assistant Minister, now in name of CASs, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 cabinet secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs.
In her ruling, Lady Justice Hedwig Agende faulted the Public Service Commission over failure to consult with the SRC on remuneration of the state officers.
It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230(4)(a). Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022.
With most of those appointed into these positions being close allies of President William Ruto, the judges ruled that despite the president enjoying powers to appoint officers into whatever office, he ought to follow the law. However, the question remains, have the CSS been receiving remuneration? And what next for President Ruto after the ruling? Well,